We'll start.
Okay. And then
This is for recording.
recording. Okay, so still need to have okay. Yeah, I think I can stand here. 好
That's your.
I can. Yeah. 他说这个只是 recording， 所以这个还是要有的。
哦，OK。
好。And how about changing the slides?
So this is forward and this is backward. Okay?
Okay, forward. Oh, but forward.
I'll play these slides for you.
You will play the slide for me? Okay.
Once it is on, so you can take it later.
Okay. Okay.
It's kept right here.
Okay. Hello, Elliot.
Well, good.
Good?
Busy as always.
Quite busy.
Welcome back, everyone. The next is a talk on protecting trade secret and resolving IP dispute litigation versus ATR. For this, I would like to welcome Yaling Gong, Senior Compliance Advisor, Yakun Law Office from China. Union Chu Partner, Hakun Law Office from China. Let's give them a warm round of applause. Over to you.
Thank you. Thank you for the kind introduction. Good afternoon, everyone. We were just wondering, I mean, my colleague Yuan Yuan and I just are wondering how many people will show up this afternoon. So I want to say thank you for coming to join us. This session, I will talk about so-called trade secrets. Originally, I honestly prepared a longer slides, but because of the changing of the timing, etc., so it has been condensed. So we will see. I will just focusing on a few points on the so-called trade secret issues, and then what are the how to protect it in China. And I invited my partner. She is a litigator. I must say that I'm not a litigator, so but I manage many of the large trade secret cases. Some are life and death. Of the company. And Yuan Yuan is engineer in the beginning, and she focusing on a patent litigation, and so on the litigation points that I invited Yuan Yuan to supplement. So that's where is the slides. I think they say they are going to operate the slide for me. Who is going to operate the slide? Yeah, I think is it possible that I just put it here and I... No? You? Okay. Otherwise, I can handle it.
我帮他吧 OK.
Yeah.
来吧
Okay.
So, now this is forward and this is backward.
Okay, so we can. So we will quickly talk a few things about trade secret. Actually, you are from many jurisdictions. I'm sure that there are a lot of the common elements. But we will also mention a few things on China, what we can do if there's a trade secret misappropriation. And we'll talk a few words on litigation and recommendation as well. So right now, most of the time that I'm focusing on all the so-called compliance matters. Compliance matters including all the from anti-dumping, anti-corruption, anti-bribery, anti-unfair competition, all the anti-things. So that's within my jurisdiction, the compliance in a 360-degree angle. In the past, I do a lot of anti-piracy, but nowadays I keep the trade secret part in my wing because I feel the trade secret parts contains really like a whole system. So I want to mention a few things about IP. In the past, IP is really like a kind of my bread and butter area in my long history of the practice. In the beginning, that I started as an IP practitioner, and then starting in U.S. I was from McDonald's. I handled the McDonald's trademark registration worldwide, and then also including the new country development, including development of the China market and Russia market and Mexico market and a few others. So kind of interesting in a sense, so importance about IP. And then I also have the privilege of observing China's development in the past 40 years, starting from 1980s to now. And I always like to show these slides, in particular to say how China is developing, why China is developing at this stage. It changes from the 1980s, when it first opened up, from the labor and from the Chinese, we say 来料加工. So you import the material here, we manufacture it for you, cheap labor. And from the labor, accumulation of certain wealth, and then to produce products, that's kind of OEM. And then from OEM, more technology, more accumulation of the wealth, and can develop the more R&Ds to ODM. And then now China in many fields, it can establish standard because it is now leading in a few areas. So if we talk about China Manufacture 2025, we can see from the first stage, from the mechanism, and then machine, water power, to mass production, and then to computer and automation, and then to cyber, and etc. So this is kind of by the stage. And I am fortunate. I was in the past 40 years observing the development of the China, including when I was in the U.S. I was at University of Illinois, and at that time it was in 1980, and the first delegation from central to provincial to cities. At that time, Shenzhen is only a small fishing village, but many of those officials, they specialize in the so-called foreign investment attraction, and they were sent to the university to learn what is international transaction. And I happened to be one of the early days at the UI Champaign, so I was the teaching assistant taking care of the officials. But I must say, I'm not growing up in China. I was from Taiwan. So at that time, it was interesting. So the professor asked me, you are going to take care of a group of the officials. Do you have any issue when you go back to Taiwan? Because at that time, two sides are not talking. But I said, fine, we are all Chinese. So I started from that time, and then later on I joined McDonald's and developing the new market, including China. And so I had the evidence, the privilege to evidence the growth of China. And from at that time, China always enjoys to attract, because all my friends from the UI Champaign in that particular international transaction seminar or the so-called camp, that all the officials are learning how to attract foreign investment into China. Even nowadays, with like U.S.-China tension, etc., I must say that all the officials that I'm talking to still have very positive recognition of the foreign investments, how important it was and it still is to play a role in the development of China in the past so many years. So from capital, from management, from talents, till now, technology. And China, of course, wants to set up standard. So and because of that, that I have over the years, I handle a lot of the anti-piracy matters when I was in 1980s. Then about 1990s, I was at Baker McKenzie in Taipei. I probably chased all of the infringers out from Taiwan to here. At that time, I have the honor to represent Disney and Warner Brothers, or the Motion Pictures Association of America, and all the film companies, including I established their licensing system, and now we see like a Disney Corner, etc. Many of the licensees were built up at that time, and I had the honor to be involved with the Disney team and to just like build up those licensing practice. So IP is really like in my heart. Although that nowadays I practice less in the IP side, but I still play one important role, that is the trade secret side. Oh, I'll come back. And why I keep trade secret? Because over the different stage of my career, I handle a lot of the in-house matters, outside matters. I was with McDonald's as the international senior counsel and overseeing the developments of the new markets and also in Asia. And then later on, at one time, I also served as the first chief legal officer for SMIC, and that is the largest foundry in China now. At the time when I was there, it was still small, but it grew very well. So I, at that time, also handled really like the most important life and death litigation in U.S. because in the eve of the company's IPO, we were sued by TSMC, and you all know TSMC is the largest foundry in the world, and so it was really like a life and death. So I always know the importance of trade secret litigation, patent litigation, 337 litigation, because everything in combined in one case, then you know how the pressure. So I felt very important to keep the trade secret in my wing, and so I'm still handling that because it is really like a system. It has to start from HR functions, because when you want to attract the talents, but at the same time, you want them to be able to contribute, but you don't want them to cause trouble to the company. So from the non-compete, non-disclosure, all those matters, that has to be started in the beginning. And then later on, when in the company, you will need to, especially the high-tech company, I set up those classification, those standards when I was with SMIC, and we also built up the patent portfolio from zero to many, and from like non-essential to essential. So I see the development and I notice the importance. So the protection of the trade secret. And then also, if something goes wrong, how to collect the evidence, how to investigate. Because if you know a group of people left one by one and joined the other company, how are you going to go there to investigate? You cannot have trespassing. This morning, I know I heard from Chris's comments about like investigation, etc. Yes, we can have a lot of tool, we can have a lot of things, but how are you going to go to competitors' company? Because it's a trespassing. You cannot even go inside. But how are you going to find out whether your trade secret has been stolen, and if so, they have been used And so how to prove that? It's very important. Then later on, of course, legal actions, warning letters, administrative lawsuit, and criminal complaint, civil complaint, and others. Most of those cases, honestly, will end up in settlement. So later on, we will talk about ADR, etc. So on the trade secret side, I'm sure that from all of your jurisdictions, it's actually very similar. It's like it can combine technical information, business information, and it must have like a secrecy of value, and then preserve confidentiality. How the company preserve the confidentiality. I was in the company, and at one time, one of the doormen came to me and said, Ms. Gong, we understand that you teach us about confidentiality, but we found that there are a big chunk of the papers just left right by the garbage can, and some of them mark confidential. What should we do? And I look at it, oh my gosh. So then, well, I traced down the person and I said, why did you not shredding all those information? Because those information belongs to the customer. It's very important. It will get the company being fined or even like terminated of this contract. And the lady told me that, well, I'm so sorry, but the shredder is out of order because we need to destroy a lot of things. But I said, no, you cannot do that. So later on, she was going to be promoted to be a director that year. I kind of just like hold on that for one more year. But at the same time, the person who poured this big truck of the documents, he was rewarded because it's really the sense. And protection of trade secret, what I want to say is not just legal department's function or just compliance department function. It is the responsibility of all of the company, from top, middle to down. So it has to be having that awareness and having that like a system to preserve, and then you need to monitor it, you need to enforce it if something goes a little bit wrong. So also in China, I think the most important thing is that you need to show like a confidential identification. It's like the secret point, 密点. When I was litigating in the US, I felt that a lot of time, the U.S. companies, in particular, the big companies, they will always say one word. It's like, all of your trade secrets were stolen from us. It's like as simple as that. But honestly, you need to prove which part and what do you have and which part, and then you need to come up with a lot of the protective measures of the company to preserve that, and then also a lot of the report to say that that belongs to you or your team developed that. So a lot of those information gathering will be very important. And I think that when misappropriation, also similar to many countries, that you obtain it or disclose it or use it or in a like a not a good manner. You're stealing it or somebody download it, or especially someone who is going to leave the company and then all of a sudden come to work in the company every weekend because he's downloading things. Then you know something's wrong. And how do you monitor it? Because in the factory, thousands of people, people are working day and night. So how do you detect that? It's very important. So it's misappropriation, assess. This person, whether he or she has access. So I always say in the company, need to know basis. Nobody should know everything. Need to know basis. In particular, in like semiconductor foundry, you have so many steps. So this section only a few people can have it assess, but no one can have the access on the whole thing unless this person is very, very senior. So this is access issue, substantively similarity. Of course, that's really like later on how to prove that you are this portion is my secret and you are using it. So in the process pattern side, more difficult. In the business information side, it's probably easier. Like evidence of the customers list, the suppliers list, those like even the price and all those things. Those are easier to prove. But in the process pattern, more difficult. And also the primary evidence, yes, identify the, and also appraisal, and sometimes it's really, as I said, difficult to get. So later on, if some of the investigating firms here would have like a good information to share, so we can probably discuss afterwards. And from the like the defense side, it's like, oh no, not similar, no contact, no secret, no access, or this has been known in the public, prior arts, all those things, or this is my self-developed. So in China nowadays, many companies are developing in the high-tech area, in the AI area, in many sectors. So always need to have good system to prove what your team has created. So later on to protect yourself, and then a lot of time can defend or can take action against others. This is just like a chart to show that it's not like just stealing. I mean, when something goes wrong, there are many type of things. Maybe breach of non-competition, maybe bribery someone to give you something, or corruption. Yeah, someone try to sell information outside. Like at one time, some of the people, young people say that, oh, we got a prototype of cell phone, like an Apple cell phone, and they sell that, or the design, a page of design of something they sell. So all those things can happen, or apply other untruthful or unlawful methods. Sometimes it's like big wrangling. During the big wrangling, you do a lot of things, exchange information, false statements, passing off, infringements. So all the combination may have a few factors to combine, and that makes trade secret misappropriation itself is a challenge to prove. So we always say how to, when something goes wrong, how to determine this is wrong, and how to identify, how to detect, and then how to investigate, and then how to take legal remedies. So this is, and if someone or a company has been accused of certain people is taking certain things into the company, how the company can form itself to also discover the facts, and then to stop the infringement, or then also take internally certain actions to defend itself. So in essence, in China, you can take civil litigation, demand for the damages. You can take AMR action. For the AMR action, later on, I will talk a little bit more. AMR stands for State Administration for Market Regulations. This is the most active organization in China to enforce on so many things, under unfair competition, under quality, under anti-piracy, under many things. Very important organization to work with. And I will talk a little bit about the latest developments on their role on protection of the trade secret. Then we can talk about criminal actions. the patent infringement, trademark infringement, copyright infringement may all have like a criminal elements to it. Trade secret misappropriation itself is also can be a ground for criminal actions. So we can talk about criminal actions and how to working with PSB. So that's, and then at the end, whether you want to pursue this till the end or sometimes between the competitors, maybe there will be settlements, negotiation for settlement. That's also possible. And sometimes why there's a settlement because a lot of time in the area, it's not just as easy as two companies fight. Sometimes this company is located in the province or the capital of a certain province. The other is the baby of the other province. How these two provinces are going to work together or fight, or at the end may go to central for determination. At that time, they may say, well, competition is one thing, but don't feel like you are like brothers are fighting, so settle it in a way. So sometimes we'll reach a settlement. Now, some of the things, for example, like a breach of non-compete. I want to say breach of non-competition agreement in China will be upheld. So non-competition agreement is okay. 18 to 20 months of the non-competition with proper payment, with proper documentation, those will be upheld in China. I know that in US, maybe at one time it's going to say abolish completely of the non-competition. I know that right now it seems to be opposed there. But just breach of the non-competition is not itself stolen of the trade secrets. So we need to make a little bit distinction there. Only if when the so-called misappropriation of the trade secrets occur, then at that time it may have the so-called the actions on what I mentioned earlier, criminal or civil or ADM involvement. So, and of course, taking all the actions, we need to talk about internal, so-called, whether there's any vulnerabilities, how strong that you protect the trade secrets in-house, how well maintained of this secret. I just quickly summarize that on the criminal action side, that can be up to 10 years of the imprisonment, this is for infringing, and then for stealing, spying, buying, may not up to that level of using, probably will also be up to a certain fixed term in imprisonment. On the administrative side, the as I said, AMR action under anti-unfair competition law will have the fine up to 5 million. Of course, illegal gain can be confiscated. There's no limitation on that. On the civil side, that right now you can have the compensation for losses, and then the commercial trade secrets of the value. I mean, how to evaluate that. That's really yesterday talk about it. How to measure the damages itself is a big topic. I have originally some detailed slides, but I kind of trim it because that's just stop here. Just yes, this will require a lot of the involvement, maybe on the third-party experts on the so-called determination. I must say that previously, China may have only fined small amount in the civil. You litigate a long time, and that, of course, in comparison with U.S., much faster in China. But at the end, may not be that high of the compensation. So a lot of clients would say whether it's worth it. But recently, there have been huge awards in certain courts, in certain cases. Yuan Yuan will talk about that later. So I also give you a diagram of SAMR. This is so-called 市场监督管理局, and this one they really have like a big, very huge responsibility on like preserve, promoting the fair competition, against unfair competition. They check on bribery, anti-bribery, commercial bribery, and then also supervision on product quality, safety, and then they also have jurisdiction over food, pharmaceuticals, and etc., etc. So AMR is a very, very active organization that all the industries need to work, and it's under the State Council. It's under the State Council. It sometimes will have private actions. They just rate the company, or sometimes they work with PSB to have joint rate. That's possible. And on AMR, they have the great power. They can enter the business premises. They can interview the business operator. They can conduct inquiries about the agreements. They can seize documents. They can seal up or detain property. For example, the computers, all the things, they can detain. And then they can also check the bank accounts to see whether someone is stealing something and get some compensation, or they can coordinate with the joint efforts, for example, with the local police on a criminal action. I also want to mention, because originally this unfair competition to protect trade secret actually has been there since 1993. But in the past, we have prepared a few cases, and the officials that we deal with always say they kind of don't want to be involved because they will feel that whether this is your secret or whether this is your secret. Honestly, for them, very difficult to check. I mean, on the copyright, on the trademark, maybe easier to look at from the appearance. But on the trade secret side, honestly, it's very difficult to say whether it's your secret or their secret. But until about a few years ago, that the recent amendment of the unfair competition law, and then also change of the policy from the central, as I mentioned earlier, to protect the so-called business environment, in particular foreign environment, because always being subject to criticism. It's like, oh, China steals something, China took something, China never enforced, etc., etc. So I think that's because of that, the government say that, okay, later on, we know that difficulty on trade secret enforcement, because who is going to investigate, right? I have the right, I have the public right, I can go in there to investigate, but you cannot, right? We are private companies. So we work with the local officials, in particular in Shanghai. So now my office has been one of the firm working closely with the AMR on how to kind of beef up this protection mechanism. So we are one of the so-called stations to help them out. I have personally gave many speeches to the officials just to talk about the trade secret inside China, and then also the US. And then maybe a little bit about Europe. So those are the things. But now, SAMR, this is also for all of your information, that if you have good clients, if their trade secret has been infringed, you can come to SAMR and seek their cooperation or seek their assistance to investigate on that for you. But you probably cannot just knock at their door, say that, oh, we suspect someone has stolen something from us. This is not good enough. If you can present more prima facie evidence or certain things, and then go to them, they probably will help out. will help out. So they will look at a few things, like whether this is more well-known brands, higher profile of the products, and then substantial loss. If this infringing or trade secret misappropriation really cause a lot of the impact on the clients or this brand, then they will consider to help out. They will consider. So we will work with them. And we have a few cases they have been helping to investigate. So that is very good. Sometimes the challenge is like we probably don't have sufficient evidence. So it's kind of chicken and egg. If I don't have some evidence, how can I convince them to help out? So we need to establish something, but they are quite open. We can work with them. So this is just like what do they like to see is like they will focusing on like well, at least the scale of the loss. The scale probably cannot be like a 10,000 RMB. I mean, probably need to be bigger and higher, so that they can put their resources together and to help out. I also want to mention this part of the AMR is a little bit different from the other part handling the anti-piracy. They are all under AMR, but different divisions. They work together, but they're still different divisions. So for this part, for the trade secret side, requirement is a little bit higher in terms of the evidence that we can get together. Like we show confidentiality agreement, the ownership, how we protect this company's trade secrets, and then how did we find out the infringing acts or what leads we have, what information we already located, and then this person, if ex-employee may have access. If this person has nothing to do with the company, may be more difficult to prove access. And then, of course, we look at the end, whether this trade secret has been used and to produce certain similar products or things like that. So all the design or certain things has been used. And then, of course, a rough calculation of the loss and damages. Okay. So I know that the organizer is having like a very tight schedule, and I know this afternoon is like a last session. So I will be very quick. I just quickly talk a little bit on the criminal actions. On the criminal action, the one important thing is about the threshold. You need to prove that the client has suffered at least like IMB 300,000 loss. Then they will qualify to like the work involved, the PSB, to help to investigate on the crime of stealing, spying, buying illegally, providing trade secret, etc., especially to overseas. So this is like the criminal elements. Criminal is like on the criminal action, you follow the lead, and then the request PSB for help, and then later on will once the prosecutor's office, PSB, already conducted an investigation, they probably will go to prosecutor's office. Prosecutors then will decide on whether to prosecute this case or not prosecute the case. And then if prosecute, then we'll go to the court. So this is like the criminal action. So I pose here for the so-called administrative side of the actions, and then also criminal actions, and then later on that Yuan Yuan will talk about the civil issues.
Thank you. Thank you, everyone. I'm very happy to share something you know about recent developments on litigation of trade secret case in China. So my sharing, mainly involves two parts. The first part, I will make, a brief introduction to China's legal system. And in another part, I will share, some of the recent developments of the trade secret enforcement practice in China. So let's begin with the first part. So in China, as we are, a civil law system, so judges will retain the full control of the proceedings from the starting of the evidence preparation to, the final trial. So sometimes for cases involving, technical aspects, like your patent case or trade secret cases, the appraisal agencies may be involved to determine whether the trade secret is valuable or whether infringement has occurred. So in view of sources of law, so we have statutes and judicial interpretation of SPC. So these two sources, they are binding, and also some local court, sometimes they will issue or publish some guidelines for the judge to make clarification in some decisions. So for these local guidelines, they are quasi-binding. So for the Supreme Court of China, sometimes or each year, they will publish some guiding cases, or we call it high-profile cases. For these cases, they are highly referential. Some local courts, the judge from some local courts, sometimes they will refer to these guiding lines. So for the court system, we have, one unified 4-tier court system, and we have 2-instance trial system. So you can see from this slide that the fundamental level is primary people's court, which is usually, in the district level or country level court. And another level is the intermediate people's court. It, or is in the city level, and we have some, some special IP courts located in Beijing, Shanghai, and Guangdong province. And the upper level is higher people's court, and the office level is, SPC, which is located in Beijing. It is the highest level. So we have 2-instance trial system. For trade secret cases, normally it will be heard by primary people's court or an intermediate people's court, depending on whether the case, involves a technical solution or not. And the second instance proceeding is usually heard, by the upper court of the first instance court. I want to mention that for some major and very complex technical trade secret case, SPC, the Supreme Court of China may hear the appeal. So how to initiate a lawsuit in China? So in 2015, so PRC courts introduced, a reform from the review system to a registration system. That means for you, if you like to initiate a lawsuit China, it becomes more easier than before, because the court will not make substantive review on the case materials, but instead they will make some registration system to facilitate the plaintiffs to file the lawsuit to the court. And we also have a statute of limitation. The general limitation period is always the 3 years in China, but courts will not voluntarily apply the limitation. As a defendant, you may raise the defense in view of the statute of limitation. So let me talk about how to determine your jurisdictional region in China. So we have 2 aspects in this slide. The first aspect is, the geographical jurisdiction, where, like the other technical or civil cases, the general rule is that the courts will also at a place of infringement or the defendant's domicile. So in view of the, hierarchical jurisdiction, it is, a little bit different for the trade secret case, because the jurisdiction will be built up based on whether your trade secret involves a technical information or not. So let me take the Shanghai city as the example. So it depends on whether your trade secret involves a technical or non-technical solution. So for non-technical information, for example, your client list, your business information, So the case will be heard, by the primary courts of Shanghai. So if your case involving, technical know-how or other technical information such as, the formula, the processes, the programs such as like these things, though normally will be heard, by the Shanghai IP court. But for some specific case, if you have, have a case of high claim value, if the case, for example, the claimed value exceeds RMB 200 million yuan, then it will go directly to the Shanghai Higher People's Court. So for the hierarchical jurisdiction, it varies across different provinces in China. So depending on the specific case, so the hierarchical jurisdiction may be different. So this slide talks something about how to file action. Like other, civil cases, you will prepare the court documents, including your statement of claim and evidence. So I think we all know that the registration system for filing a lawsuit is more easier than before. Especially, for foreign entities, it's now very convenient for you to, file formality documents to China. We have no legalized procedure now. You have your documents such as POA or certificate of incorporation notarized, for example, by U.S. notary, and then apostilled by competent U.S. authority. So it is very easy for you to make your formality documents executed and file it to the Chinese People's Court. So the court suit can be filed online or on site, depending on which court you choose to file the lawsuit. So this slide shows some, very general things about how the trial proceeding will proceed. So in China, trials are often conducted by way of oral hearings. They will be consisted of opening statement and then the court investigation, and also we have a session of court debate and closing argument. As you all know, we have no jury, so we have no jury trials in China. So in view of production of evidence, so we have no discovery mechanism, but court sometimes they may ask some party to provide evidence. So it is worth noting that, especially for some technical cases like the patent infringement case or trade secret cases, punitive damages are available in China. So for this aspect, I will talk a little bit more in the another slides. So let me share, some recent trends we've observed for the trade secret protection and enforcement. So according to our observations, so Chinese court now, they are more willing to award high damages in trade secret cases. So in this slide, we have made a chart showing from the year 2018 to the last year, how the damage of the case evolves. So you can see from this chart, so for the damages case over RMB 1 million, so the chart showing that the trend is increased. So we want to highlight 3 important cases where high damage awarded by the courts. So for the first case is melanin case. I think it involves a chemistry production line where the court awarded the high damage of I think RMB 98 million yuan. Another important case is rubber antioxidant. Also, I think it also involves a chemistry. The court in this case awarded damage of 202 million yuan. Another case, I think it appears involves some software, the software of centrifugal compressor. So in this case, the court awarded a damage of 166 million yuan. So all these cases show that there's a trend that Chinese courts now they are more willing to issue high damages if you can demonstrate you know your trade secret, you are the right holder of the trade secret, and also demonstrate you have a high value of this case. Another trend we have observed is that about the punitive damage, as I just mentioned, punitive damages are now available in China's court system. So this chart shows we have made a chart from the year of the 2021. In this year, the judicial interpretation on punitive damages are published in China. So the SPC, a spokesman from SPC, also say some words about the punitive damages to emphasizing the Chinese court now a strengthened enforcement in view, of technical cases such as the trade secret cases or patent infringement case. So in this slide, we show how to evaluate whether a punitive damage should be applied in a case. So according to the SPC judicial interpretation, some factors will be considered when how to or should the court apply the punitive damages. We have two indicators. The first one is whether there is malicious or intentional of the defendant, and another one is whether the circumstances are serious or not. So about the malicious intentional infringement, the court will consider maybe the repeated after warning. That means that if the defendant has been warned, but he still continued the infringement of the trade secret. Another thing is the former insider or had access. That means if the defendant they have a former employee, or former manager, or former senior manager of the plaintiff, and they have they have confidentiality liability to the trade secret. However, they still choose to disclose or misappropriate the trade secret. So this is also a factor the court will consider when applying the punitive damage. And another indicator is about the serious circumstances where the court will evaluate whether the infringement the infringement still continued after penalty, and also the court will evaluate whether the damage is severe or not, or whether the defendant he will destroy the evidence or try to hide the evidence subjectively. So we have a case highlighted because in this case a very high damage was awarded by the Supreme Court. You can see that the damage in this case awarded is about RMB 6 billion and 14 million yuan. It's very high, so it is. I think it's high profile cases in China, and also in these cases, I think the SPC they applied a punitive damages. I think maybe if I remember correctly, the punitive damage the multiply is 2 times. So for this case, we have made a comparison with the SPC judicial interpretation when how the defendant their intention is malicious and how the sequence is serious. So in this case, it is a very interesting case because the defendant he was the former senior former senior employee of the plaintiff, and he poached I think maybe nearly 40 employees of the plaintiff and then built up a new entity, and they have continued disclosure of the trade secrets. So after evaluation, the court think that the defendant's action has caused very serious consequences, so the court applied punitive damages in this case. So another trend we have observed is about PI, preliminary injunction. So although historically we have observed PI is relatively rare in the civil cases of China, but now we think that they are increasingly used to prevent the irreversible harm. once a secret is disclosed, so its legal value will be lost. So PI, we have observed the courts are applying PI in some trade secret cases. Those are key factors considered by the courts for apply or grant a PI. We can elaborate into 4 factors. The first factor is preliminary proof of ownership. So as an applicant, you have evidence to show that you're the right holder of the trade secret. And the second one is the likelihood of infringement. So you have provide reasonable grounds to the court. So make the court believe that the infringement is occurring now or will occur. So you also show to court the urgency of the case means that you have, imminent risk of disclosure or loss of your trade secret rights. Another one is, the balance of interest. The court will weigh the plaintiff's harm versus, the defendant's burden. So because trade secrets, they are highly vulnerable to irreversible harm, because if the trade secret is disclosed, its economic value will be lost. So PI are becoming, a crucial role for a crucial tool for the court to early intervene into high-risk cases. We also give some 2 examples in view of the PI aspect. The case 1, is about Robert Bosch was his former employee. So it is a foreign entity. So background is this former employee, he emailed some confidential documents of this company to his personal account just before he leaves the company. So the company find the facts and then finally very proactively initiate the application of PI to the Suzhou court. So the PI was applied and granted within only 1 day. So it is very quick for this company to get, a granted PI in this case. Another case is also an interesting case because it involves the gaming industry of China. So the applicant in this case is a gaming company which develops many new games. And for this one, the respondent is a personnel, so he is actually a gaming tester of this company, because before some versions of games are released, they will hire some testers to testing how they feel about the new version of the game, such as the role or the character of the games. So for this case, the tester, they take some photos and videos with his own personal device to still try to disclose some character design of this game and try to release such information to the public. So the gaming company, they just notice that through their internal monitoring process and then initiate the application of PI to the court. So this is involved the Shanghai Pudong court. So they granted the injunction within 2 days, about 48 hours. So this is 2 cases showing that the court now willing to issue or grant PI in trade secret cases as long as you can demonstrate or provide some prima facie evidence to show that you're the right holder of the trade secret and also the case is very urgent. So in summary, I'd like to conclude that the trade secret protection and enforcement landscape in China is evolving rapidly now, and compared with the previous, with before the court, the Chinese court now are better equipped to make protection and enforce the trade secret, and also the court are now more willing to award high damages for the trade secret cases or other technical related cases such as patent case, and also PI you can leverage this kind of tool to initiate a remedy, or early remedy channel for you to enforce your trade secret. So this is my sharing about trade secret litigation. So as Michelle just mentioned, because unlike the patent case where you have a registered IP right to show that you're right holder for a trade secret case, you have to show to the court at least you have the right to enforce the IP. So as Michelle just mentioned, the early system construction is very important for trade secret case for you to enforce your IP right. So Michelle will talk now about this.
Sure. Thank you. Thank you, Yuan Yuan. So preliminary injunction, this is kind of new. I will just quickly bear with me for 2 more slides. Yeah. Because of the U.S.-China tension and because of certain things that occurred in Trump 1.0, for example, China initiative, and a lot of the scientists, a lot of those Chinese, scientists in particular in the U.S. has been detained, etc., for trade secret violation. Of course, if they really did something, steal something, well, of course, it is justified for the action. But sometimes some of the professors, even including non-Chinese professors, has been subject to investigation in that in China initiative. Of course, later on, China initiative was suspended during the Biden administration, but now Trump 2.0, maybe some of the things will be back. So we are just thinking that maybe there will be more and more of the, especially the high-tech war, etc. Maybe there will be some cross-border type of the actions. Micron, for example, is having a fight with some of the high-tech company in China. So I think this will be more. And we just think that, for me, long-term protection of the IPR, so I would think that all of us, we hope that we will be very busy in the area and we can continue the discussion. I think that the last thing of my presentation is that there is a system, and this trade secret protection, it needs to have a system in the company. The earlier it is set up, the better. So I will end up my discussion here. I know that we are under the time constraint, so we will be going to the final session. Thank you. And later on, if you have any questions, I will be around. Yuan and I will be around. Oh, no, you have to attend a court hearing. So I will be around. We're welcome to have further discussion. And thank you so much for staying up with us.
Thank you so much. On behalf of IIPLA, we are honored to...
Thank you.
Thank you.
Thank you.
One second.
Thank you.
We can have a group.
Oh, we can have a group. Okay.
Two of us.
Okay.
Thank you.
Okay.
Up.
push. 慢点，慢点。OK， 我们走这儿吧，谢谢。
Thank you so much.
Thank you.
Thank you. Thank you for your patience.
Very good.
在周律师面前班门弄斧了，不好意思，
Very good. Very good. Very good.
班门弄斧，班门弄斧，
Thank you.
班门弄斧，班门弄斧。
The court hearing online is
我坐
scheduled
那边，
for 4 p.m.
我等一下再回来。
Okay. Thank you very much. Thank you.
Thank you, thank you. Thank you for staying with us. Give me my card.
Now at the court him
Yeah, I have been
scheduled
feel
for
for
4
a
p.m. this
long
afternoon.
time. And I'm still quite
走了，还有个法庭线上谈话。你走吧，我明天会被进去。使馆人保持联系。拜拜。
I think she's good.
Oh, sorry. I was stolen.
Yeah, please. Just look at the camera.
Sorry. Can I have this? Can I have this?
Oh, yeah, sure.
इस पर देखना क्या मैं इसीलिए कह रही थी ये वाली टेबल यहाँ रख देते हैं फिर वॉइस ना क्लियर हो जाएगी सब ठीक है रख दो इसकी आएगी
All right, let's move to the last session of the day, which is session 9, protecting trade secret and resolving IP dispute versus Asia. We now move to a final session, and this session is moderated by Mr. Thomas Ye, partner at Clearly Gottlieb from US, with the panelist Ya-Ling Gong, Senior Compliance Advisor, Hong Kong Law Office from China, Mr. Wang, partner, Globe Law Firm from China, Zhou Jiang, lawyer, Zibai Partners from China, Bozo, partner, Shishu Partners from China, Shija Li, partner from Pagenta Partners, China. I welcome you on the stage.
Where should we sit? Tell us.
Free for all.
我刚讲，我去坐后面好吧？You sit later. I just spot, right? 来，师家到前面，师家到前面。这里，你往这边，我不好坐那么中间。我和八号还在一起。
Short instruction, do not press it for a long time, it will get switched on.
Okay.
So just hold it for this.
Okay.
Thank you. The other mic is sharing.
Okay. Thank you.
Great. Well, welcome everyone to the last and final session. After these 2 days of discussing various issues in IP and many different types of disputes, it's fitting our last session asks how we resolve disputes. And so this afternoon, as IP disputes become more global and more complex, I think more and more clients are asking, are there alternatives to going to court and litigating and fighting to the death? And so I think this panel will focus on IP litigation and pros and cons and different factors to consider between traditional litigation and ADR. Before we begin, perhaps each of the panelists can say a brief introduction.
For me, my name is Zhou Qiang. I showed up here today already. I'm a Chinese lawyer based in Beijing. My name firm is ZY Partners. We have focused on IP-related legal matters for years, and we really have some unique experience on trade secret litigation. I would like to share those experience with you guys. Thank you.
Good afternoon, everyone. My name is Wang Zhenzhi. I have been working as a lawyer for over 20 years. Mostly I spend time doing litigation and arbitration. 4 years ago, CPAC, I'm not sure whether you know this institution, is one of the best arbitration institution around the world. Started a program called China Intellectual Property Arbitration Annual Report. I was honored to be the chief editor of that annual report. So today I will be very honored and pleased to share with you about that. Thank you.
Hello, everyone. This is Michelle Gong again. I am a senior attorney in the IP or compliance field for many years. Now I am with Han Kun, pure Chinese local law firm. We have like 800 attorneys. And previously I was with Baker McKenzie, pure global firm. Later on I was with another, McDermott was a local firm as a joint venture company. So I've been with global, pure global office, and then JV, strategic alliance, and then now the pure Chinese law firm. My firm doesn't have like exclusive relationship with any firm outside, but we work with everyone. So very happy to be here. Thank you.
Good afternoon, ladies and gentlemen. My name is Li Sijia. I'm a partner at Fangda Partners, and I'm based in the Beijing office. Our firm is actually a full-service firm, including 200 partners and 1,000 attorneys. And we have offices in Shanghai, Beijing, Shenzhen, Guangzhou, Nanjing, and also we have office in Hong Kong and in Singapore. So we would like to think of ourselves as one of the best law firms in China. Of course, as the same as Han Kun and the rest of the law firms attending this conference. Actually, I don't specialize in IP litigation. I have to state my disclaimer. So if I'm wrong on any IP-related issues, please forgive me. Rather, my focus is on commercial dispute resolution, including litigation and arbitration in China and also in the rest of the world. We collaborate with a lot of foreign law firms in assisting our clients in foreign litigations and arbitrations. So I look forward to achieving collaboration with all of you, and it's really an honor to be a panelist for this session. And I want to thank you. I want to express my heartfelt gratitude for all of you for staying for this very last session, because we were talking with Michelle and everybody else. We were a little bit concerned that people would have left at this very last session, and it's great that you're still here. Thank you.
Thank you.
Hello, my name is Bao. I'm a partner at Sugar Partners. Today I'm very glad to be here and share some of my thoughts regarding IP disputes and also international arbitration ADR. My main focus is not in IP-related matters, but in international arbitrations, and most of the cases are about commercial cases, and we started by HIC, CI, ICC, IIPLA, and some other institutions, also including CTEC and BAC. So today I expect to contribute more from perspective of international commercial arbitration, and also I'm pleased to learn from my esteemed colleagues, fellow colleagues, and also of you. Thank you.
And as previously stated, I'm Thomas Shan, I'm a partner at Cleary, Gottlieb, Seton, and Hamilton. Previously, I was a partner at Latham & Watkins, where I was for 13 years. Just recently moved law firms. I do have to comment, Michelle, from your previous session, we actually shared an employer. My first job was at McDonald's, although I was not in the legal department, I was in the hamburger flipping department.
I was sent to the Hamburger University for like 2 weeks because they say that I need to develop the China market. So therefore, all the other attorneys being trained for 1 day. I was there for 2 weeks, and the store manager was very happy to torture, as you know, the lawyers. And so I was there working from early in the morning till the end, but I really learned a lot of things because you appreciate where is the money from. And so I always tell my team, etc., I say, we need to know, no matter which client that we have, we need to know their business. We need to appreciate where did they earn the money to pay our legal fees. So we appreciate the client's business.
And with that, we'll start with Mr. Zhao. So in IP disputes, what are the most common types of ADR procedures you see companies and clients employ?
Okay. So from my experience, as I mentioned, I'm a litigator, and from IP-related legal disputes, I don't have many experience with regard to ADR. This is my opinion. However, I like to add some information. It's not directly related to IP, but just general civil dispute and administrative disputes in China. This is the official statistic issued by Chinese Supreme Court for 2023. Entire China, there is about 12 million cases settled or mediated by Chinese court before officially get into the litigation. So this is about almost 40%, almost 40% of disputes. The people have dispute and come to court, and before they start litigation, and there is a special group in the filing department, and they go there, their voluntary negotiation procedure. We call it mediation. You can just like ADR. And through that non-judges, maybe retired judges, with other officials, just mediate the dispute. Through this way, they settled about, in China, these are official statistics. This is reliable. About 40% of disputes, including civil and administrative disputes, being solved in this way. So that's very significant. This is for the 2023 and 2024. That's also official report. The Chinese Supreme Court make a report to National Congress. It's also about 12 million disputes, civil and administrative disputes solved through mediation. So this ADR is this kind of ADR is very significant in China. Okay, I stop here.
I think Mr. Zhou is right by saying there are a lot of cases, especially in IP fields. now solved by mediation. You can see the case numbers are increasing almost every year. From arbitration point of view, I'm not sure whether you know this. In China, we have almost 300 arbitral institutions. The number is increasing too. Someday, I'm sure it's going to be over 300. The cases in front of arbitration also increasing. The case load for the 10 judge, 10 major institutions. The case load above 1,000 cases. I mean each year. For these cases, let's take CTAC as our example. 15 of them, that's about 150, sometimes nearly 200 cases are IP related. As an arbitrator, as a CTAC arbitrator, I hear cases over 10 cases each year for myself. Sometimes presiding arbitrator, sometimes solo arbitrator. From my own experience, I can see, like 10 years ago, almost nobody can get IP case. I mean, in CTAC. But now each year you have like 150, sometimes 200 cases there. They are a group of IP arbitrators specializing in hearing IP cases. We know each other. We meet quite often. We all agree the number of IP disputes increasing, and some of the cases now come to arbitration. So for ADR, I think arbitration has its own, advantages to solve IP disputes. I will stop here and listen to other panelists' contribution.
You want to say something, or you want to throw new questions?
We can do either. I'll ask you a new question, Michelle, new question. So do you see any differences in the ADR context for disputes that are domestic versus cross-border disputes?
Sure. In my opinion, I'm wearing the previous hat as the in-house counsel, as the chief legal officer. We established like a kind of a system. If we will be sued, for example, we built a lot of the semiconductor plant, we may be sued by the contractor or somebody. In that situation, then we always say that litigation, because you need to prove the other party, if they want to sue us, they need to prove that they will win. Then we will pay, right? So usually we do that. But if there are other things like license, arrangement, etc., we probably will prefer arbitration simply because confidentiality issue. We do not want to have like an open trial on certain things, and our trade secret or our development of certain thing, IP will be disclosed to the public. So in that situation, then we will choose arbitration.
So it depends on the situation. In the IP area, as I said, license or cross license, or you have the agreement, acquisition, etc., then you can use like arbitration simply because the nature of the business. But on the other hand, that on the so-called infringement, there's not possible to have like a discussion on the agreement to go into arbitration. In that situation, we usually would say that fight first. I mean, even if we need to defend very strongly, then we probably can have the settlement. Or we need to fight very aggressively in order for the other party to kind of surrender and then to have the settlement. Because as I said, in the IP area, very, very complicated because it's really like a competition among the competitors. Also, a lot of involvement on the government, for example, like 大基金. I mean, invest on here, and if these companies are fighting with each other, it's at the end, that's the government is involved. So they usually will say, okay, we want you to respect other people's IPR, but you defend yourself, but at the end, please do not disturb the stage of the development of your business. So please settle it. So a lot of time settlement.
Yeah, Thomas, I guess the question was the difference between the resolution of domestic IP disputes and that of the international IP disputes. I think that is a very interesting question because apart from the fact that in global IP disputes there would be the complexity of applying different governing laws and even maybe applying the relevant IP conventions, I think a pragmatic difference is that when resolving a local dispute, I think people sometimes focus on resolving the dispute itself. But when resolving an international or a global IP dispute, I think it's more of a commercial bargaining process because we face a lot of global IP disputes nowadays, especially among the high-tech companies, high-tech Chinese companies and high-tech US companies. Everybody knows that Chinese companies and US companies are suing each other like crazy these days. It's more of a result of political and also commercial tension. It's not about the dispute itself. So I think a very pragmatic difference is that in resolving a global IP dispute, sometimes instead of responding to an attack launched by the other side, we will need to find a more favorable or friendly forum to launch our own attack. And those attacks would even themselves out. For example, in the disputes between Oppo and Nokia, I think at first Nokia was suing Oppo all over the world, in India, in the United Kingdom, in all kinds of jurisdictions, arguing that Oppo has infringed upon the SEP owned by Nokia. And they were also filing claims seeking for licensing fees with very high disputed value. And I think what Oppo did correctly in that series of disputes was that Oppo not only actively defended itself in all of those proceedings filed by Nokia, Oppo also took the initiative to file a series of SEP disputes in China. And then Oppo achieved a favorable result before the Chongqing No. 1 Intermediate People's Court, which set a global terms regarding the SEP. So I guess that is something correctly done because in that way, Oppo not only defended itself against the foreign jurisdictions, but also it finally found a favorable jurisdiction to resolve their disputes, on a global basis, and then the parties reached a final global settlement. And I'm saying this because I'm very glad that Fangda was a part in that case. And I think that is particularly the difference between resolving a local IP dispute and also of a global IP dispute. You need to find the correct forum to launch your fight. Yeah, that is something that I want to share.
Yeah, I think probably quickly add, I think Shida is very correct because in the IP field, that especially cross-border, a lot of the time right now it's not just the technology. it's also like the countries, the politics, and all the things involved. So always need to have a strategic plan. That's really very important because it cannot be just like a lawyer's fight. It needs to talk a lot of things, needs to involve a lot of things, and then where to pick up the fight. If, for example, when I was sued, when I was very young, then I probably will not throw too many stones because the other party are much more powerful. It will only irritate them. They will just act, 10 patents, they probably act 300 patents and sue us everywhere. So we need to be very careful in that regard. So, but I agree with you. If we are going to be stronger, then we need to think about to defend and then maybe to fight, and then so all those things are strategy and plan. Thank you.
Okay, thanks. I will give my comments on the first two questions together by dividing the IP disputes into contractual-related disputes and non-contractual related disputes. In terms of like contractual disputes, like a license agreement or like technology transfer agreement, if the parties to the contract are located in different jurisdictions, I think most parties will choose international commercial arbitration. The reason is very simple, because one party cannot fully trust the state court of the opposing party. So sometimes international commercial arbitration with arbitral seat in a third-party company is the only solution that can be mutually accepted by both parties. So that is not about advantage of arbitration, but that is sometimes only the arbitration can make commercial sense because the parties are located in different companies. But if the parties are located in the same company, for example China, and two Chinese companies enter into a license agreement, and when they might still prefer arbitration because of like confidentiality considerations, they would still prefer arbitration. But there is one tip that if there is no other foreign-related elements, because two parties are both Chinese parties, there might be, if there is no other foreign-related elements, they cannot choose international arbitration, like in Hong Kong or in Singapore. They can only select a Chinese arbitration convention like BAC or CTEC. So that is the most common tool. So I would say to contractual related IP disputes, if that is a global IP disputes, most people will choose arbitration as the foreign. But if that is a domestic, maybe many people, if not most, will still choose arbitration, I believe. But if that is an IP infringement, well, it will further divide into two scenarios. First, this infringement is still related to a contract, like a license contract. The licensee might use the technology by exceeding the scope of the license agreement in terms of the territory or scope of use or time period, and that might constitute both the breach of contract and also infringement. And if the arbitration clause is broad enough to cover related infringement, then this infringement dispute can also be solved by arbitration. But if there is no contract related, it is a purely infringement or unfair competition or infringement of trade secrets. In practice, it is not very common for parties to reach a separate arbitration agreement after infringement happens, so they can only choose litigation or mediation. And the statistics has say that in the recent 3 years, the percentage of cases that party withdraw before the final award because of mediation or negotiation settlement, the percentage is much higher in IP disputes than regular commercial disputes. And I guess that is because in the area of IP disputes, the two parties are usually have some cooperations before, or they need to choose some other business purpose, or they're just afraid of their reputation being tainted by the litigation or arbitration, so they will discuss more carefully than they do in commercial arbitrations. So I think that can help questions. Yeah.
Yeah, and following up on that, one thing that I've always wondered about being from the U.S. jurisdiction is, in the U.S. we have extremely broad discovery. so oftentimes even broader than arbitration. So that's one factor to consider in litigation. In a trade secret case, for example, we're going to get to depose everyone, we're going to get our forensic investigations. But in other jurisdictions like China, it's almost the opposite because discovery is so limited. So my question is, how does the availability of discovery factor into advising clients are choosing between arbitration versus litigation? I'll open the floor to whoever wants to start.
Well, I'm happy to start on this topic. Well, I think, Thomas, you're absolutely correct. I think in China it's almost the opposite. Because we don't have a very mature system in court proceedings for discovery, I think. We have a similar mechanism where a party would be permitted to make a document production request to the other side, but I don't think there's a very mature or there are not that many case precedents where courts can rely on, and I think it's a highly discretionary matter whether the court would direct the other party to submit that document. But as a comparison, I think in international arbitration proceedings, at least tribunals can refer to rules like the IBA rules on the taking of evidence. I think the reference schedule is being used in many international arbitration proceedings. And although domestic arbitration institutions like CTAC and BAC, not in every the international style reference schedule is not used in every domestic arbitration case, but many our arbitration institutions are adopting guidances and guidelines to allow the tribunal to exercise jurisdiction, to exercise their discretion to use a similar mechanism as the discovery proceeding, which is similar to that of the international arbitration. But coming back to your question, I think it's almost the opposite. And actually, we are currently representing a client in a infringement case. It's not the infringement of patent or something, but it's the infringement of the client's plant variety rights. And in that case, we are facing tremendous difficulty in obtaining evidence that the other side is infringing upon our plant variety rights because, the subject matter is plants. The plants are in complete custody of the other side. We cannot really take samples to run a test to see if they are infringing upon our client's plant variety rights. And in that case, I hope we do have I hope we can make use of the discovery proceeding like that in the United States, but unfortunately we don't have it. Then I guess the court's decision as to whether to grant a document production request is highly discretionary. It's almost on a case-by-case basis. So I guess that is one of the main differences between the China and the US in terms of discovery.
I want to add one more comment that it is generally true to say that China does not have a system called discovery like in the US. But Chinese court will still do some factual investigation by some means. I will introduce two main means by which Chinese court will do factual investigation. First is called the attorney's search order, under which one party can apply to the court by describing the documents that they need to get and explain why that is important and why that is relevant to the case. And if that application is granted, the court will issue an order, and the attorney of one party can take this order to a third party like a bank to ask the bank to produce a bank statement of the respondent, or to some administrative bodies to produce like a real estate recordal of the respondent, something like this. But I want to mention that this is very largely different with the discovery because such search order can only be used to a third party, not the respondent himself. And the third party is always some like big entity, like bank or administrative bodies. It will not be used against the respondent himself. But in the IP disputes, I think sometimes the key information, key documents is not kept by third party, but that is kept by the respondent or the holding party himself. So I don't think search order of Chinese court style can be very helpful in IP or trade secret cases. And the second means by which Chinese court will do factual investigation is called the production order of written documents, which means by this system, if one party can prove that to the satisfaction of the court reaching a high threshold that the opposing party must have some written documents in his possession, then the court will order this party to produce it, and failing to cooperate with this order will trigger the adverse inference. But it seems like quite similar to discovery, but in fact they're quite different. First of all, this can only apply to written documents, not all the evidence like data or other documents, only written documents. And the second, the proof threshold is very high in terms of what is to the satisfaction of the court that it must be in the opposing party's position. In my experience, you need to prove something like according to the contract has two copies, one kept in the claimant and another kept by the respondent, and now the claimant provide his copy, and the respondent challenges but not provide his copy, the respondent copy. And in this scenario, maybe the court will say, okay, you need to, if you want to make the challenge, you need to provide your copy of the contract according to which you should have one. And if they refuse to produce a copy, then the court will say, okay, I will infer that the version provided by the claimant is true. So, but according to, for example, if that is, if the discovery US can apply, one party can ask the other party to produce something like the board meeting minutes or some design, historical versions of the design, which according to the common sense should have exist and should be in the position of the other party. So that would be established in US discovery, but in Chinese, the order of written documents, I don't think it can meet such threshold, such high threshold. So, so that is why I agree with my colleague that the fact investigation in Chinese court is not sufficient to deal with trade secret or IP-related disputes. And in this, to this aspect, I think the international arbitration will do much better than Chinese court, like HPIC, AAA. I have done a lot of cases in AAA and HPIC, which have such system like discovery, maybe not as powerful as US court, but that can still meet can still serve some functions in terms of IP disputes. So that's my comments. Thank you.
Yeah, sorry, I just wanted to add one point regarding the document production requests. I think ultimately for the mechanism to be powerful enough, at the end of the day, the court would have to draw adverse inference at some point. But a practical obstacle that we face in IP litigations in China, I think is that sometimes courts are reluctant to draw adverse inference, even if one of the parties is completely uncooperative towards the document production process, because I think Chinese judges are used to, it's a mentality point. I think they are more used to the parties presenting the evidence to support their claims. That is embedded in the very root system of the Chinese civil procedure law. But when the parties fail to produce the evidence that the judge needs to decide the case, even if one of the parties is completely incooperative to the document production process, I think the judge will feel reluctant to decide the case just based on adverse inference. So I think even if, as Bao said correctly, there are some similar mechanisms in Chinese civil procedures which might be considered as similar to that under the US court system. I think eventually the practical effect of those systems are sort of limited.
I just had a comment on that. It's interesting that what it sounds like is you get an adverse inference, but it really does not have much teeth. In the US system, it's almost the opposite, because if you have an adverse inference at trial, you have the judge telling the jury, hey, here's the adverse inference that the jury is going to listen to. So it's almost a death knell sometimes if you get an adverse inference against you in a jury trial. I guess one question for you, Mr. Huang, is have you seen, when there are potential criminal proceedings or parallel criminal proceedings, how does that affect the ADR process?
Well, for IP cases, we do like trade secret cases. We do have the process or the actual example in the court. Well, one party said, well, this the other party offense, criminal offense, but the process is a civil process at the moment. Well, theoretically, the law says, well, everyone or anyone during the process should transfer the case to the police or to the prosecutor. There's such a system in Chinese law, but in reality, either civil court judges or the parties, I mean either plaintiff or the associates, but it's big challenge for them to persuade either civil court judges or the administrative staffs to transfer the case to the police. But there are cases like trade secret case. If the let's say the first instance trial say, well, this damage was a certain amount of money. It reached the minimum standard of the criminal defense. Well, the parties may take this judgment, take the court decision to the police, saying, hey, look, this is the evidence. But the lawyers, as far as I know, Chinese lawyers, we practice across the country. It's not like a US system. One firm, same firm or same lawyer will have